by not joining issue with them, you're attacking them on the procedure. You know, where's your authority to stop me? Where's the jurisdiction? Do you own the highway? Is it your road? And there's a couple things that I have on the traffic as far as jurisdiction is concerned, which I'll go over after I go through this. Okay, so you want to avoid the answer, and you can do that by filing a motion to strike, and there's elements of a motion to strike on what qualifies their claim against you for putting an answer in. You don't have to put an answer, maybe not. You may have to, but to do all the things that you're able to do before you have to answer. Yeah, there's a motion to dismiss, and there's a whole bunch of motion to dismiss cases in there that he talks about, not just one. Okay, ask for a more definite statement. It's vague and ambiguous, and it's void for vagueness. If the complaint doesn't really come out and give details, and it doesn't meet the criteria or the elements, you can demand that he or she files a more definite statement. Perhaps the sentence doesn't even make sense. According to the English language, we have to have a noun and a verb in a sentence, and a lot of these statements that they use on these complaints don't even have verbs in them. So how can you understand what they mean? When I took English in school, I said one of the things, I don't think I'll ever diagram a sentence again. But once you get studying law, you start seeing in these cases, when they start coming after you, you read them, they don't know the law, they don't know English either. And it's done specifically to cause us delay and to not understand what they're saying. And everybody says, well, I can't make sense out of the law. Well, of course not, because it's not even written in proper English. It's not the syntax language. Well, that's by design. They're taught this stuff. So we have to hold their feet to the fire on every angle we can. We have tons of bullets in our arsenal here. Another one is our affirmative defenses. And he's got 3 different chapters on affirmative defenses. You know, well, there's no proof that I was the one that was there. Where's your proof? I have reason to be there. You know, it's my property. You can't get me for trespassing on my property. And there's a whole plethora of affirmative defenses. Okay, then in the event all of those fail and you have to answer the complaint, then what you do is you answer the complaint. He gets into how you answer the complaint, and then once you answer the complaint, one of the next things that he recommends to do is discovery. Now, discovery can be done in the beginning of the case. It also can be done at the time of an answer. Now, in discovery is where you're going to decide what the ultimate facts are. You're going to get all the facts that you can about the case that they're coming after you for. Okay, you have, first of all, the request for admissions. You ask them, are you such and such, and were you the one that was in the car that day that you're claiming that I did such and such? Well, no, I wasn't. My wife was the one. You know, okay, so you're getting all these admissions. They either admit or they deny, and all these lead to the case. And then in the tutorial, the video, he goes with a lot of different ideas on how to go about doing this. I'm just giving a rough draft of what he's saying on here. But he really gets into this and makes it really interesting. Okay, the next one is the request for admissions. Then you have the request for the production of documents. Any documents that they have that's going to substantiate their claim against you. And you want to be looking at this when you're doing this both ways. Whether you look at it on one side that they're coming after you and you're the defendant, and then on the other side, you're the plaintiff, and you want to go after somebody. So it works both ways for both ends, and he covers that. It's not just a one-sided thing as a defendant or one-sided as a plaintiff. So the next thing after he does the production is interrogatories. Okay, interrogatories are nothing more than just questions. You ask questions, and they have to answer these questions. And of course, these are all done through the court, and they're sworn to. So they have to tell the truth. They have to tell the truth. Okay, the last thing is the depositions. You can do depositions, and the depositions are where you would call the person who's filing against you in the lawsuit, or the person that you want to sue, and you're calling them to a deposition. You can have a deposition anywhere. You could have it in a men's room. You could have it in a room like this. It could be in a legion. It could be in a courtroom. It could be anywhere that you choose. The person putting the deposition on will choose where they're going to have it. There will be a court reporter there. You have to hire a court reporter. These people that come in are sworn to under oath, and you ask them pertinent questions about the case. And this, you only get to depose them one time. And this is your ultimate facts, evidence, material that you're trying to obtain for the case to prove your innocence, or to prove their guilt if you're coming after them. Okay, the other thing, you have subpoena power. Okay, you go to the clerk and you're able to issue subpoenas whereby you can subpoena third-party witnesses. You can bring in people who know what's about the case, and people who maybe your witnesses that have been with you, or people that were with them that know more about the case, or as much about the case that you need information about. Okay, after that, the compelling discovery, the next thing is moving the court. He talks about how we move the court. The court doesn't move by itself. We file papers in, and then we sit back and we wait and we think, well, why doesn't the court do something? I lost a federal court case in the Western District here in Buffalo when I sued Cattaraugus County. And I lost it because I didn't have this course. I didn't move the court. I had all this paperwork in, and I was fighting 27 attorneys by myself. And I held them off until oral argument. And I kept filing papers and filing papers. And I never set it for a hearing on the motions. And I just sat there waiting for them to do something. And they twiddled their thumbs, and they're laughing and partying and everything, and saying, this guy ain't going to file no hearing or anything. He's not going to move the court. So we're not going to do nothing. And they didn't do anything until the time expired. And because I didn't do anything about it, my case was ultimately dismissed. And even though it was dismissed, the judge says, oh, he was right all the way. He did everything right. And he was violated, and he has a claim against the county and everything. But the ultimate answer that he gave on the very last line of his case was Judge Gretny. He says, however, they have immunity. But anyway, that's a whole other case. That's something different. But we have to move the court, keep our case going. And keep in mind that we are standing in power, whether we're a defendant or whether we're a plaintiff. Never to be fearful, never to be afraid of the judge or the prosecutors, because at that point, we're going to have done our studying and our paperwork, and we're going to know what's in our paperwork. And nobody knows our case better than we do. So the best thing is to just hold your ground, hold your feet to the fire, and stick by all the facts that you've pulled out. Affirmative defenses you want to state in your answer. Again, even though in the motions, all the motions, if they turned your motions down for dismissal because it was a sham, if you turn your motion to quash down, you still put your reasons in as your affirmative defenses. You go after the jurisdiction of the court and the jurisdiction of the party that's coming after you. You hit them hard. If they're coming after you, now you've got the 11th Amendment, depending on who's coming after you. If it's a private person, the 11th Amendment probably will not apply. If it's a government official coming after you, a county or the town, the water department, or somebody for the sewer guys, or garbage people, or the dog warden, now we got the 11th Amendment. They don't have any power in law or equity to come against the people. So by using the jurisdictionary law procedure program, we can use all of our affirmative defenses, and we can hit these guys and hit them hard. Okay, the next thing is, he talks about knowing the law, what the law says. We have to understand that for each instance, each case is different. If they come after me with one thing and come after him with another, or even the same one, chances are the law is different for me or for them. Even though the law does not apply to us, and we're going to show them that in our paperwork, we need to know what law they're coming after us with, and how they're determining that it applies to us. Okay, yeah, I agree, that's your law. How does it apply to me? Is it contract? Did I sign a contract? Where's your jurisdiction over this, over me? And jurisdiction is something that you always want to attack. If you don't attack it and you don't raise it, then they consider that you waived it. And once it's waived, you can never bring it up again. Okay, writing the memoranda. That's the cases that had already been pre-decided by the appellate courts, Supreme Court cases that ruled already that will say that the sovereigns are the ultimate power, and it's never been overturned. You have the Miranda case, Miranda versus Arizona, that says the legislature has no power to create any laws, rules, or statutes against the people. Well, if they can't make any laws, rules, or statutes against the people, how are you applying these rules against me? You know? It can't be both ways, guys. You know? It's either one way or it's the other way. Okay, and he explains on how to do the research, the legal research, with the authorities. You want to use authorities. Authorities like you have the CFR, you have the titles, USC codes, you have the Constitution, the United States Constitution, you have New York State Constitution, you've got the Magna Carta, there's tons and tons of authorities in the Declaration of Independence, the Bill of Rights. There's cases after case in every area that we're up against that have case sightings where they rule in our favor. And we need to dig them out and to use them in our paperwork. And once we do that, then we have set up our authorities. And then the nice thing is that he talks about sizing up your opponent and looking at him and finding out, is this guy, does he do this to everybody, just try to get money out of people, or is he legit? A lot of people file felonious complaints against people, and you can get them for misuse of process. And looking at the reasons he's doing this kind of thing. Maybe he just needs extra money and he figures you're an easy target. Well, guess what? We're not going to be easy targets anymore. We're going to stand our ground and we're going to say, well, wait a minute here, now it's time for you to prove the elements of your causes of action. And I'm going to hold your feet to the fire. Okay, the next, he talks a lot about using the rules of evidence. And that's really important. Hearsay is not allowed. Affidavits, if they file an affidavit against you, an affidavit is not allowed. It's hearsay evidence. I don't know how many people know that. But you would think an affidavit that's sworn to under the penalty of perjury would be good fact paper to use as to substantiate a claim against you. Well, an affidavit, in order for it to be any worth whatsoever, the person who files the affidavit will say, the guy is filing a complaint against me, and he's got 3 affidavits from his 3 sisters and his brother-in-law, and he files them into the case, and they're swearing to the same thing that this guy has in his complaint against me. Well, that's hearsay evidence. The only way this guy can document anything is if all those people that filed an affidavit are there in the court, whereby, or in discovery, where I can cross-examine them and to ask them specific questions relating to their affidavit, and to get it on the record in person. But just to have a piece of paper, if you think you're going to help your friends out, or your mother or brother or somebody, by filing an affidavit in support of the claim that they're coming after him for, it ain't going to work unless you're there and you're able to defend it, and you have first-hand knowledge. Very important. You got to have first-hand knowledge. You can't say, well, so-and-so told me, or such and such a person